Good day and welcome to Epstein Becker Green's webinar, A Year in Review, What's New in the World of Trade Secrets and Non-Competes. We are pleased to have three fantastic speakers today. Epstein Becker Green's David Clark, Senior Counsel of the Litigation and Labor and Employment Practices, Robert Goldstein, who's a member of the Litigation and Healthcare and Life Sciences Practices, and Peter Steinmeier, who's a member of the Labor and Employment Practice. Before we begin today's presentation, please be informed that today's webinar is being recorded and the participant phone lines will be placed in listen-only mode throughout the program. You are welcome to submit questions throughout the program by using the Q&A feature provided by WebEx, which can be found on the right-hand side of your screen. At the end of the program, with time permitting, the speakers will address your questions. You are also welcome to submit questions directly to the presenters following the webinar, and contact information will be displayed at the end of the presentation. In approximately 2 to 3 business days following the webinar, Epstein Becker Green will communicate the availability of the recording and access to the PowerPoint materials. At this time, I'd like to turn the webinar over to Peter.
Thank you very much, Kirsten. And good afternoon, everyone, from the city of Chicago, where we are mourning last night's ignominious defeat of our beloved Chicago Bears on Monday Night Football. My name is Peter Steinmeier. I'm one of the co-chairs of EBG's Trade Secrets and Non-Compete Practice Group. Joining me in the presentation today are Rob Goldstein and David Clark, both of whom are in our New York office, and both of whom, like me, spend a majority of their time dealing with issues involving restrictive covenants, trade secrets, and the like. And what we'll be talking to you about for the next hour are significant developments in these areas of the law, and hopefully at the end we'll have a few minutes left for Q&A, and you're free to submit any questions through the submission apparatus that you have via our WebEx. Starting with the topic of developments in restrictive covenant law, which is what I'm going to be talking about. The most significant development in the last few years in the Illinois and arguably nationally was a case that came out of Illinois, which is what's on my first slide, involving what is adequate consideration for a restrictive covenant. This case, Fifield versus Premier Dealer Services, came down in the summer of 2013. And in this case, the Illinois Appellate Court for the First District, which is the district that includes Chicago, held that absent other consideration, 2 years of employment is required for any restrictive covenant to be deemed supported by adequate consideration. And the court further held that that was true even where the employee signed the restrictive covenant as a condition to his initial employment offer, and it even applied if the employee voluntarily resigned. So when this decision came down, it essentially upset about 30 years of established understandings as to what was adequate consideration for non-compete in the state of Illinois. And the bar was really taken aback by this decision. So we all thought that surely, given the magnitude of this decision, the Illinois Supreme Court would weigh in, but it didn't. And then we thought, well, surely other Illinois appellate districts will weigh in, but they haven't. But as is reflected on the next slide, federal district judges in Chicago have started to weigh in on this decision and whether or not it in fact is binding. And here's what's interesting. Judge Castillo is the current chief judge in the U.S. District Court for the Northern District of Illinois. And Judge Castillo held in 2014 that the Fifield decision was not consistent with existing Illinois law, and therefore he was not bound by it, and he's not going to apply it. In contrast, Judge Holderman, who was the chief judge immediately prior to Judge Castillo, came down the exact opposite way in a case that he issued in May, holding that, look, we're just federal judges sitting here, and we have to apply Illinois law, and this is the most recent Illinois appellate court decision, therefore we're going to adopt the decision. Therefore, I'm bound by the decision. So Holderman applied it, Castillo refused to apply it, and so that's where we're left. And so the question is, if you have employees in Illinois who have a non-compete, the question is, well, what is adequate consideration apart from 2 years of actual employment? And again, we haven't really gotten any guidance from the courts on this. The trial courts, the state court trial courts in Illinois have been applying Fifield, but we don't have any appellate decisions thus far applying this or interpreting what is adequate consideration. So among the things that the practitioners have been kicking around and discussing are things such as paying cash, paying a bonus for a non-compete, providing stock options or other incentive compensation, making a meaningful promotion contingent upon signing a non-compete. The other thing that we're starting to see more of is employers adopting garden leave provisions in lieu of a pure non-compete. And a garden leave provision is essentially just a requirement that an employee give advance notice of their resignation, typically 3 to 6 months. And the idea is the employee has to give notice of their resignation, but they remain an employee and they continue to be paid during that period of time. And as a result, because they continue to be an employee, they owe a duty of loyalty to their employer. It's another way of dealing with this uncertainty in the state of Illinois regarding what is adequate consideration for a non-compete. Now, in my next slide, I talk about a case that came out of Pennsylvania last year, which was not a change in Pennsylvania law, but it does illustrate some of the differences in the law that are taken by various jurisdictions. In this case, it involved an at-will salesman in the basement waterproofing industry who had signed a non-compete after he was already employed. And so the court held, and this was not a change in the law, but the court held that mere continued at-will employment is not consideration under Pennsylvania law, and so the court refused to enforce the agreement. Again, no change in the law, but it's something to be aware of. And so what we are looking to see is whether this Fifield case that came out of Illinois is going to set off a trend that may be copied in other states. So pay very, very close attention to consideration issues when addressing non-competes. The reason why it matters is you can have a case like Fifield come down 5 or 10 years after you've had all of your employees sign a non-compete, and then the law changes, and lo and behold, you're sitting there facing a situation where an employee is in court trying to get their non-compete thrown out because there wasn't adequate consideration when under the law that existed when they signed it, there clearly was. My next slide talks about a slightly different but nevertheless interrelated issue under Massachusetts law. Massachusetts has a doctrine called the material change defense, which basically holds that a restrictive covenant is not enforceable if the employee's job duties, compensation, or employment relationship substantially changed between the signing of the non-compete and the time when the employee left the company. This was a Massachusetts created doctrine. It hasn't been directly adopted by other states, but it was reiterated in 2 recent Massachusetts decisions. So it's something to be aware of. Why is it something to be aware of? Well, in this time of corporate change, mergers, acquisitions, spinoffs, et cetera, will a non-compete signed 5, 10 years ago still be enforceable today? I mean, there may be and should be successorship language or signability language in the non-compete itself, but by virtue of all of those corporate changes, mergers and acquisitions, will the definitions in the non-compete still be applicable today? I mean, if there's a definition of a competitor, has that changed? If there's a definition of the industry, has that changed? What about the employee's duties and responsibilities? Have those changed? So what that whole doctrine indicates is that it makes sense to periodically review your non-competes to ensure that they're still enforceable. But when you do that, keep in mind the consideration issues that I just talked about in connection with the Illinois and Pennsylvania case. My next slide is kind of an interesting one that caught my eye because of the nature of the industry. And the question in this case was limits on corporate competition. So when 2 corporations enter into an agreement in which one of them agrees not to compete with the other corporation, will that agreement be analyzed the same way as if a corporation had entered into an agreement with an individual employee? This particular case arose out of the Emmy Award industry. I guess there's a company in Illinois that manufactures Emmy Awards. the little statutes that are given out at the Emmys. And it had agreed not to provide its statutes to any other person or entity. And when it did so anyway, it was sued by the other company for allegedly violating the non-compete. And what the court held was that an agreement between corporations not to engage in certain competitive activities is not analyzed like an employer-employee non-compete. Rather, because there's no imbalance of power, contract enforceability is analyzed like any other arm's length transaction. So the Northern District of Illinois said corporations are different when they strike deals. Now, my next slide talks about a New York case that we think is a bit of an outlier, but nonetheless it's out there. In this case, two companies had entered into what we call a non-poach agreement as a result of a prior settlement in which they agreed not to hire certain employees. These are common agreements when settling non-compete lawsuits or non-solicit lawsuits, but in this particular case, the court refused to enforce the non-hire agreement. Now, my next slide, I talk about why the court reached that decision. In New York, as in most states, there are certain legitimate protectable interests that will be held sufficient to support a non-compete. And in this particular case, listed them in New York as protection of trade secrets, protection of confidential customer information, protection of the client base, and protection against irreparable harm where the employee's services are unique or extraordinary. And the court held here that the plaintiff failed to tie this no-hire agreement into one of these four legitimate business interests. Consequently, it refused to enforce the non-compete or the non-hire agreement. Now, again, why did I pull out this case? Why am I talking about this case? It's something to watch. It's something to be aware of, even though we think it is an outlier as applied to this particular case. In many states, such as Illinois, where I practice the bulk of the time, there is a legitimate protectable interest in protecting the stability of the employer's workforce. We've started to see courts chip away at that a little bit. Courts have said, hey, look, you can't protect a 50,000 employee workforce unless you have a really, really significant reason to protect all 50,000 of those employees. Maybe you can protect a certain subset of them or people you dealt with, but you can't just use an overbroad protection. So the Illinois courts are starting to chip away at this. And again, it's just sort of it's something to watch to see how courts continue to view non-poach agreements between two companies. On my next slide, this again is a case that's a bit of an outlier factually, but it's one, again, to be aware of. And the case is an Illinois case talking about whether there is a distinction between officers and non-officers when it comes to what is acceptable conduct by an employee of a company. In this particular case, there were employees who were not officers who asked customers and suppliers of their current employer what they thought about their formation of a new competitive business. Now, they didn't actually cross the line and actually solicit, but they clearly, and they admitted this, intended that those conversations would persuade customers and suppliers to eventually do business with their new business. Now, I talk about on the next slide the fact that the Illinois Appellate Court held that it was not an abuse of discretion for the trial court to conclude that these conversations were merely permitted preliminary actions that did not rise to the level of a breach of an ordinary employee's duty of loyalty. And on the next slide, I talk about the court's rationale for its decision. What the court did is it drew a distinction between the duty of loyalty owed by ordinary employees and the duty of loyalty owed by corporate officers. The court said that ordinary employees can plan and outfit a competing corporation so long as they do not commence competition, but corporate officers are held to a higher standard. And the court held that in this circumstance, because they were merely employees and not officers, they didn't cross the line. Now, I think this is a really, really close call and, frankly, a factual outlier, which may have had a very different outcome if the appellate court hadn't been merely reviewing the district court's decision for an abuse of discretion. That was the deferential standard of review that was applied. So when weighing the precedential value of the decision, I would keep that in mind. But nonetheless, an interesting case. The next topic that I want to talk about is the topic of injunction bonds. Injunction bonds are something that the attorneys in injunction proceedings frequently never give any thought to until the court has either issued a TRO or issued a preliminary injunction, and then the attorneys are left up at the podium stammering in front of the judge, and the judge says, well, what do you want me to do about bond? There are very, very few cases that talk about what is an appropriate injunction bond, and there's one that came out this year, and because there are just so few, I thought it was noteworthy, and that's why I talk about it today. To review, under the federal rules of civil procedure, a district court has great discretion when setting the amount of an injunction bond, and I've got the standard quoted there. The court may issue a preliminary injunction or a TRO only if the movement gives security in an amount that the court considers proper to pay the costs and damages sustained by any party found to have been wrongfully enjoined or restrained. Now, as I talk about on the next slide, states take different approaches with respect to bonds. In Illinois, where I primarily practice, no bond at all is required. In Indiana, on the other hand, a bond is required in an amount sufficient for the payment of such costs and damages as may be incurred or suffered by any party as found to have been wrongfully enjoined or restrained. In other words, the Indiana standard is similar to the federal standard. And so on the next slide, I talk about this Indiana case that came out this year where the trial court issued a token injunction bond or required a token injunction bond of only $100. And the appellate court reversed, applying the literal words of the applicable Indiana Rule of Civil Procedure and holding that that amount was simply unacceptably small. So with that, I'm going to hand over the program to Robert Goldstein, who will be discussing developments in the law regarding trade secrets, starting with the case which discusses the potential ramifications of a cease and desist letter, which is how so many trade secret lawsuits begin. With that, Rob, I hand it over to you.
Thanks, Peter, and thanks to everyone who's joining us today. As Peter mentioned, my name is Robert Goldstein. I'm a partner in the New York office of Epstein, Becker, Green, where a large portion of my practice is devoted to trade secret and non-compete litigation. I'd like to spend a little bit of time going over some recent cases over the past year that are of interest in the world of trade secret litigation and raise some interesting notions that can be derived from those cases. First, I'd like to talk about the case of Rick Bonds v. Phillips Electric North America, which is a district court case that was commenced in Michigan involving a cease and desist letter. Now, as many of you probably know, cease and desist letters are fairly standard in most trade secret disputes, and they really can serve an important function, not only by quickly putting all interested parties on notice of a potential misappropriation, but also triggering preservation obligations prior to commencing litigation. And they can also have the effect of having subsequent employers take corrective action if they become aware that a rogue employee has taken information from a prior employer. Under those circumstances, subsequent employers may also decide to take disciplinary action against a new hire who took confidential information. And that's where some employees who are the subject of disciplinary action decide to pursue a claim against their prior employer for tortious interference or defamation because of the impact that the cease and desist letter had. And that's what we see here in the Rick Bonds v. Phillips Electronic case. In that case, the employee at issue worked not only for Phillips Electronics, but also for a competitor at the same time. This was a clear violation not only of Phillips' non-compete provision, but also Phillips' internal policies. So, not surprisingly, Phillips terminated the employee and then followed up with a letter to the employee that was also copied to the employee's subsequent employer, or the simultaneous employer, I should say, reminding the employee of his confidentiality obligations, and also expressing concern that the employee may be using Phillips' confidential information on behalf of the new employer. The new employer decided to terminate the employee because it was concerned about getting involved in litigation with Phillips. As a result, the employee turned around and sued Phillips, claiming that the letter Phillips sent tortiously interfered with his employment with the other employer and sought damages as a result of his termination. Well, fortunately, the court dismissed the employee's tortious interference claim because it determined correctly in that case that the cease and desist letter was a legitimate effort on Phillips' part to protect its confidential information. So what are some of the lessons that can be learned from the Phillips case? Well, I think it sends the message that employers can and should feel comfortable when they're sending appropriate cease and desist letters, and when appropriate, also sending those letters to a subsequent employer when there's a belief that the letter is necessary to protect a legitimate business interest. For example, if an employer has what it believes to be a valid, enforceable, restrictive covenant prohibiting the solicitation of customers, and the employee is now violating that provision, it is not inappropriate to notify not only the employee, but also the subsequent employer of those concerns, provided that those concerns are legitimate. With that said, it's still important when drafting cease and desist letters to make sure that they're done in a way and prepared in a way that does not give an employee or a competitor the ability to assert a claim on the basis of the letter. So what I generally recommend as being a good idea to try and limit exposure is keep the letters as factual as possible, lay out the basis for the concerns that are expressed in the letter, and certainly avoid making any gratuitous or disparaging remarks that might be used as evidence of a malicious intent. These are very often emotional situations. Even with large companies, people can get emotional when they feel like a former trusted employee has stolen their information or is brazenly violating an agreement. It's really important to try and not let any such emotions take over, because if a poorly drafted cease and desist letter can create more problems than it solves. And going to my next slide, we can look at another recent case that is an example of what happens when an employer does overreach and asserts a misappropriation claim without having an adequate basis. This case, FLIR Systems v. William Parrish, was initially commenced in 2009 in California. In that case, the employer asserted a misappropriation of trade secrets claim against two former officers, fairly standard, straightforward claims, but the judge denied the employer's motion for injunctive relief on the basis of a lack of evidentiary foundation, and even went so far as to award the defendant $1.6 million in attorney's fees because it found that the employer in that case did not have a legitimate basis for asserting its action. The employees then were emboldened by the court's ruling. They turned around and sued the former employer for malicious prosecution, and they even went so far as suing the employer's lawyers, Latham and Watkins, also asserting malicious prosecution. Initially, the malicious prosecution case against the lawyers, Latham and Watkins, was dismissed on statute of limitations grounds, but in 2014, that claim was reinstated because an interim case interpreting the statute of limitations actually pointed to the survival of the employee's malicious prosecution claim. So that case and the employee's claims is a good illustration of what can happen and how an effort by an employer to assert claims, misappropriation claims, can really backfire if the employer overreaches. What that should tell employers is, don't overreach. If you have a solid basis and have a legitimate, good faith reason for pursuing a claim against an employee, employers or even a competitor, employers shouldn't hesitate to assert those claims and will generally have immunity, both qualified and litigation immunity, for asserting those claims. It's only when an employer tries to use a misappropriation claim as a competitive weapon without a good faith basis that it can get into trouble. So before pulling the trigger and asserting a claim in court or even sending a cease and desist letter, make sure that you have some basis. You don't have to be right. It can turn out that you will assert, make allegations of trade secret, and a court may disagree. That's okay. What's not okay is asserting a claim for an improper purpose, to get a competitive advantage, to teach the employees a lesson. That's all fine if you have a legitimate basis for asserting the claim, but that should not be the sole motivation, basically because it's going to backfire and you not only face losing the case, but also potentially having to pay the employee, which is obviously the worst case scenario. Now, turning to another recent case that I think is useful for employers pleading trade secret claims is Job Science v. CV Partners, which is a federal court case that was commenced in 2014 by a plaintiff who sued a licensee and a competitor, a newly formed competitor, alleging that the licensee stole proprietary software code and was using it for competitive purposes. Here again, not a particularly unique claim, fairly standard, especially nowadays with software code being the subject of so many misappropriation claims. What was interesting about this case and what's, I think, instructive is the employer in this case also included a copyright infringement claim. And software code is protectable in most instances under the federal copyright statute. The problem in that case occurred when the court decided that the copyright claim was a legitimate claim and stated a valid cause of action, but because of that, it preempted the state law misappropriation claim that was based on the same common nucleus of operative facts. So that left the employer with just the copyright claim. In that case, it was okay because the employer had registered the software with the Copyright Office and was therefore able to take advantage of the copyright statute's statutory remedies, which can be significant and include an award of attorney's fees. However, in many instances that I've seen, software code that employers develop or proprietary code is not registered with the Copyright Office. Unregistered code can still be the subject of a copyright claim, and you can retroactively file a copyright registration to support a copyright claim, but if the code at issue or whatever material at issue was not registered with the Copyright Office at the time that the infringement took place, the plaintiff is limited just to actual provable damages as a result and cannot take advantage of any of the statutory remedies under the copyright statute and does not have the right to recover attorney's fees. So there's really a limited set of damages that are available under the copyright statute in those cases where otherwise copyrightable material was not registered with the Copyright Office at the time of the infringement. So what does that tell us for practical purposes when asserting misappropriation claims that may also implicate statutory IP claims such as copyright or patent infringement? The first thing to bear in mind is you can avoid preemption by making sure that you include alternative claims that may arise from the same general set of facts, but are qualitatively different than just a misappropriation or copyright claim. The problem that occurred in job science was that the trade secret misappropriation claim was essentially identical to the copyright claim. It was just asserted under a different legal theory. But if you can plead a claim that is qualitatively different than a straight copyright claim, it is likely to survive a preemption argument. And the example that I have in the slide, which I think is pretty straightforward, is a breach of duty of loyalty. To the extent, for example, an employee takes an employer's computer code and brings that code to a new employer, that would not only potentially implicate a claim for misappropriation of trade secrets, it could also be a copyright violation, and it could also support potentially a claim for a breach of that employee's duty of loyalty or fiduciary duty if that information was taken by the employee when he or she was still employed by the employer. If the defendant asserts a preemption argument with regard to the copyright claim, that might have the effect of eliminating the misappropriation claim, but it is not likely to eliminate a qualitatively different claim such as breach of duty of loyalty because the elements are different, even if the common facts are identical. Another factor that should be taken into account when pleading misappropriation claims is to think about the types of trade secret information at issue to determine, is this the type of information that is copyrightable, that falls within the scope of the copyright statute? We've been talking about computer code, and that clearly does fall within the scope of the copyright statute, but there are many other forms of confidential and trade secret information that do not implicate the copyright statute, and thought should be given to the distinction between copyrightable information and non-copyrightable information. For example, as we state in the slide, business strategies, customer preferences, marketing strategies, pricing strategies, those sort of conceptual trade secrets, even if reduced to writing, would not be generally considered copyrightable, and by including those in a misappropriation of trade secrets claim, if the facts support it, you can successfully avoid getting into a preemption argument. One last sort of practical issue that we can take from this case is when you do have material that, proprietary material that is subject to the copyright laws, and that again is usually software code, it's not a bad idea to consider registering it with the Copyright Office. By doing so, you give yourself that additional protection under the copyright statute, and in the event it's ever misappropriated by a former employee, you can not only assert whatever common law rights are available to the extent they're not preempted, but you can also take advantage of the copyright statute's statutory remedies, which can be significant, and the award of attorney's fees that's available under the copyright statute. So it's something to think about. It's not a lot of effort to register code with the Copyright Office, and it can ultimately become a real advantage if that code is ever subject to theft or misappropriation. So while we're on the topic of federal statutes, I want to spend a few minutes talking about the Computer Fraud and Abuse Act, which is another federal statute that often comes up in trade secret misappropriation claims. And from my practice, I've seen the CFAA being used more and more in cases against employees and competitors who are accused of taking confidential information, particularly in today's electronic age where so much information is accessed and transferred electronically. And in almost every trade secret scenario that I've encountered over the past few years, there's been some form of electronic transfer of information that could give rise to a CFAA claim. Now, the thresholds for bringing a Computer Fraud and Abuse Act claim is not very high. All you need to do is show provable damages of at least $5,000, and that can include the cost of a forensic exam of a former employee's computer, which, if any of you have used some of these forensic firms, you know that it's very easy to quickly meet that monetary threshold. But you also have to show that the employee or defendant in a CFAA case accessed the employer's computer either without authorization or in excess of authorized access. That language has resulted in a great deal of debate over the past few years regarding what is actually meant by the term authorized access. And what we've seen over the past few years is two conflicting interpretations that have emerged among the various district and circuit courts. Interpretation number one is a fairly narrow interpretation in which the courts that have ruled on the issue have decided the CFAA is really a remedy for hacking by third parties, was not intended to apply to employees, and to the extent that an employee may have had access to an employer's computer, authorized access, the CFAA does not come into play, and it's not unauthorized access if the employee accesses the computer, even if the employee exceeds the employer's authority and steals information. Under this more limited interpretation, the courts conclude the authorized access applies to generally the access to the computer and does not encompass exceeding that authority by stealing information. So in those cases where this more limited approach is taken, employers are still free to assert all the common law claims and any other statutory claims that may apply for misappropriation, but the CFAA claim will not survive if the employee did have authority to access the computer. The other interpretation that has emerged over the past few years is a broader construction of the CFAA in which the courts have determined that when an employee exceeds his or her authorization, even if they were allowed to access the computer, if they access the computer to steal information or otherwise engage in unauthorized activity, the CFAA can come into play and the access would be considered unauthorized. So there are a lot of situations where under the broader interpretation, interpretation number two, an employer will be able to successfully assert a CFAA claim that would not survive in a district or circuit where courts take the more limited construction under interpretation number one. So looking at a common scenario, if you have an employee who is planning to resign and go to a competitor and surreptitiously goes into his or her employer's computer system, downloads trade secret information, puts it on a flash drive, and walks out the door. In those cases, if you're in a district that takes the more limited approach to the CFAA, you may face dismissal of a Computer Fraud and Abuse Act claim if the employee, notwithstanding his or her clearly unlawful activity, if they had the authority to access the computer, even if they stole information from the computer. Whereas under that same factual scenario, if the case is brought in a district where the more liberal or broader construction is adopted, you would have a clear Computer Fraud and Abuse Act claim. And the benefit that many see with asserting a Computer Fraud and Abuse Act claim is not only the sort of the gravitas of having a federal statutory claim and all of the implications that may bring, but it also is it provides a basis for federal court jurisdiction that might not otherwise exist. So there are times where the CFAA can be a valuable claim that employers will want to assert if that claim is available. So we basically all have to wait for the U.S. Supreme Court to definitively rule on the issue. That has not happened yet, so we're still faced with different courts in different circuits reaching different conclusions. And in a recent case involving this issue, the court took a very interesting approach to this dilemma by essentially punting. In that case, it's the Mocha Systems, Inc., the Barnier case that was commenced in the District Court of Massachusetts. The court determined that it wasn't going to rule on whether which approach it was going to take on the authorized access definition because it did not have binding circuit court authority one way or the other. And in that case, the court decided that because the pleading could support a CFAA claim under either the more liberal interpretation or the stricter interpretation, it was going to defer ruling on the issue. So essentially, the court kicked the can down the road, perhaps hoping that in the interim, the case would either get resolved or there would be some interim decision by the Court of Appeals or by the U.S. Supreme Court finally resolving the issue. But in any event, because the court was persuaded that the claim could survive under either interpretation, it felt justified in not resolving the issue. I think the issue, the main lesson from that case and just from the general state of the law right now, the uncertain state, is when you are looking at potential claims that you may want to assert in a misappropriation context, if you are considering a CFAA claim, you want to be sure to check in the district that you plan on bringing the claim to determine whether the appropriate Court of Appeals that district is a part of has ruled on the issue. Many of them have, but there are still some circuits that have not definitively ruled. If there has been a definitive ruling in that circuit, you should be guided by that ruling as to whether or not you have a valid CFAA claim. And in those circuits where there is no definitive ruling, it's still worth looking at the district court decisions, if any, on the issue to see, is there a general consensus among those district courts, or are they also in disagreement over the issue before making a final decision as to whether or not you have a valid Computer Fraud and Abuse Act claim. Until the Supreme Court rules on the issue, your employers and anyone who wants to assert a CFAA claim against a former employee is going to have to go through that exercise before deciding whether or not it can and should bring a CFAA claim. One other thing that can be derived from the Mocha Systems case that may be helpful is, if it's at all possible, when pleading a CFAA claim, if both scenarios can be addressed, that will obviously minimize the chance of an early dismissal for failure to state a claim in those districts where the more narrow construction is adopted. Obviously, facts will determine whether or not you can plead under both theories, but some consideration should be given to that to determine whether or not there is some basis to plead a CFAA claim that could survive a motion to dismiss. While we're on the topic of statutory claims, I'm going to turn now to state statutory claims, and in particular, California state claims under California statutes. Now, most of us are probably aware that California is very unfriendly to post-employment restrictions, that would limit an employee's ability to work for another employer. But in one recent California case, there's a reminder that whatever views California law may have about post-employment restrictive covenants, California will still protect an employer's trade secret and confidential information. In that case, Angelica Textile Services, the Park, the court made several rulings that are applicable to trade secret claims in California and confirmed California's willingness to protect trade secret rights. One of the first rulings in that case that's of significance is that while the California Uniform Trade Secrets Act, the California statute protecting trade secrets, does preempt other common law tort claims that are based on the same operative facts, the California statute does not preempt breach of contract claims that may be brought as a result of a misappropriation. So for those of you who have confidentiality agreements with employees, if those agreements are breached and an employee misappropriates trade secrets, if that takes place in California or a California court is reviewing the issue, you will not have to choose between a breach of contract action and a California Uniform Trade Secrets cause of action. They can coexist without the California statute preempting. The Angelica case also confirmed that, similar to what we talked about with the Federal Copyright Act, CUTSA will not preempt tort claims, even if they're related to the misappropriation claim, if there's an independent, qualitatively different legal theory that's asserted under state law. And, for example, a breach of duty of loyalty, which we talked about in the context of copyright law, by the same token, a breach of duty of loyalty claim brought in California on the basis of stealing trade secrets would not be preempted by the California statute because it is qualitatively different and involves different elements. Another scenario would be stealing proprietary information that may not fall within the scope of the Trade Secrets Act because it doesn't qualify as trade secret, but is nevertheless protectable as proprietary and therefore would survive a preemption claim, particularly if it's in breach of a contract. The Angelica case also clarified an interesting point that everyone should remember about Section 16600, the infamous California anti-restrictive covenant statute. That statute does not invalidate non-compete provisions to the extent that they impose any limitations on an employee's conduct during employment. Many non-compete provisions not only prohibit post-employment competitive activity for a period of time, but also include the provision during your employment and for a period of X years after your employment. To the extent that a non-compete provision imposes a limitation on an employee's conduct during employment, it does not run afoul of Section 16600 and can support a valid claim by an employer. Now, turning to the next slide, given the broad range of remedies that are available for a misappropriation claim, and we've talked about a variety of them with the cases that I've been discussing, let's not forget that stealing trade secrets is also, in many instances, a crime. And everyone should bear in mind that if there are facts to support it, it would not be inappropriate to notify law enforcement authorities of that crime in the event it takes place. And in a Northern District of Illinois case from this past year, United States v. Yihao-Pu, I hope I'm pronouncing that correctly, an employer sued a former employee who stole proprietary computer code for quantitative trading, but also, in addition to the civil action, brought the matter to federal authorities. Pu was arrested in 2011, and as a result of the federal authorities' investigation, a co-worker, Sahil Upal, was also arrested for misappropriation because he helped Pu. He transferred the stolen code to Pu's computer, and even worse than that, or equally bad, I should say, he tried to conceal, to cover up the misappropriation by hiding Pu's computer and then actually destroying it by dumping it in a canal. Now, obviously, in a civil context, that can give rise to spoliation claims and a number of sanctions in a civil context. In a criminal context, that's also obstruction of justice, and Upal was appropriately charged with obstruction of justice in addition to numerous additional criminal counts. Upal pleaded guilty to the criminal charges, and because of his actions, he now faces up to 20 years in jail. It's very unlikely that he will serve that length of a sentence, but this serves as a really good reminder that there are criminal penalties and associated with misappropriation, and if appropriate, federal authorities or state authorities should be notified, with one caveat. Bear in mind that even if it is appropriate to notify law enforcement of an employee's misappropriation, keep that completely independent of any civil remedies you may be pursuing. The last thing you want to do is use any kind of criminal proceeding or threat of criminal proceeding to gain any form of leverage in a civil proceeding. There should be no hesitation in notifying authorities, provided that that's being done purely because it's the appropriate thing to do and not because it's to get some kind of advantage in a civil claim. Similar to the overreaching that we talked about the earlier case, can ultimately backfire and lead to trouble down the road. So that's I think, the lesson that we can take from the U.S. v. Yihao-Pu case. And with that, I'm going to now turn this over to my colleague, David, who's here in New York, and ask him to continue on.
Thank you, Robert. Good afternoon, everybody. I'm going to touch on three notable cases from the past year relating to choice of law and venue, and then I'll wrap up with a quick update on legislative efforts in 2014 in the trade secrets and non-compete area. Choice of law issues often arise at two particular times. The first time is during the drafting of a restrictive covenant agreement, when an employer must decide which law to designate as governing disputes arising from the agreement. The second, later time, is when that agreement has been violated or is about to be violated by the employee, when an employer is considering whether and where to file a lawsuit to enforce the restrictive covenant. Often it works out that decisions made by an employer during the earlier drafting period can either help or haunt the employer during the later period, when it comes time to make tactical litigation decisions on which court to file suit in. A case from New York's Appellate Division highlights these issues. In Brown & Brown versus Johnson, the court refused to enforce restrictive covenants against the defendant, Teresa Johnson, in a suit brought by her employer. When Ms. Johnson had begun her employment, she signed an agreement containing restrictive covenants barring her from soliciting the employee's clients or employees for 2 years after termination of her employment. Now, normally in New York, depending on the facts of the case, of course, the employer would have a good shot in enforcing these types of non-solicit provisions. Here, however, the employment agreement provided that it was to be governed by Florida law, and the New York court found that to be a problem. Florida has perhaps the most comprehensive and detailed state statute concerning restrictive covenants. Most of the statute's provisions are pretty harmonious and have similar policy considerations when compared with New York common law, but the court honed in on two specific areas that differ markedly from New York common law. In evaluating the reasonableness of restrictive covenants, the Florida statute expressly forbids courts from considering the hardship imposed upon an employee, and also provides that any such covenant must be construed in favor of providing protection to all legitimate business interests of the party seeking enforcement. So the court found that these two pro-employer elements of the Florida statute were truly obnoxious when compared to the policies articulated under New York law. So, the lesson here is for employers who use Florida choice of law clauses in their restrictive covenant agreements outside of Florida, they may wish to reconsider that designation, as this case could be, used against them and prove detrimental to enforcing those covenants. If they stick with Florida law, they should be prepared to deal with this case and its effects. No discussion of choice of law in the context of restrictive covenants is complete without a mention of California. As many of you know, non-compete agreements are generally void as against public policy in California, as Robert was mentioning earlier. So, as a general rule, employers seeking to enforce non-compete agreements try to stay away from California courts and choice of law clauses, while employees seeking to avoid enforcement welcome the idea of litigating in California. These concerns played out in a decision rendered in 2014 by the Northern District of Illinois, where a California resident was sued by his former employer, Brunswick Corporation, which is headquartered in Illinois. The California resident, whose name was John Thorsell, had been a vice president of sales for Brunswick's Life Fitness division. Brunswick asserted several claims against Mr. Thorsell, including breach of his non-compete agreement. When Mr. Thorsell sought to dismiss the case, the court found that numerous connections of Mr. Thorsell to Illinois, including an Illinois choice of law clause in his agreement, led to the conclusion that venue was proper in Illinois. Now, he had some other connections to Illinois. The state was one of his sales territories. He traveled to Illinois to negotiate his non-compete agreement, and he acknowledged in the agreement that Brunswick's principal place of business was in Illinois. So in this case, at least in part because of the choice of law clause, the employer was able to avoid the dreaded prospect of seeking to enforce a non-compete agreement against an employee in a California court. The final case I'll discuss today, in some respects, looks like a mirror image of the case I just finished discussing, only without the California connection. Like Brunswick Corporation in Illinois, in this next case, Banyan Software Services, an employer with headquarters in New Jersey, sought to sue an out-of-state former employee on its home turf in New Jersey State Court. But the results of this suit were the opposite of the Illinois case. Here the case was dismissed. How come? Well, while the defendant worked as a computer systems analyst for Banyan, she lived in Illinois and serviced clients in Illinois and Ohio. She never actually worked in New Jersey or for any New Jersey-based clients, and she had never traveled to Banyan's New Jersey headquarters. So when a party brings a lawsuit, the court must be able to exercise personal jurisdiction over the defendant, meaning the defendant must have had some minimal contact with the state or federal district in which she's being sued. Here, even though the defendant's employer was headquartered in New Jersey and she received payment from that New Jersey corporation and submitted timesheets and reports to the corporation in New Jersey, the New Jersey Appellate Court found that these contacts were not sufficient for the corporation to sue the defendant there. The court found that these contacts were attenuated at best and insufficient to subject the defendant to personal jurisdiction. In other words, she had not purposefully availed herself of the benefits of conducting business in New Jersey and therefore could not be hailed into court there. So, this case gives clues as to how an employer with a global or remote workforce can manage its ability to bring suit against former employees where it chooses, especially if it wants to sue them in its own backyard. Such employers may employ a variety of approaches to bring such employees into their home court, including requiring employees to make periodic trips to the company headquarters to attend meetings, or engaging those employees with clients in the home state, or setting up reporting relationships with managers at headquarters. Employers can also consider including contractual provisions in employment or confidentiality agreements in which the employee consents to submit to personal jurisdiction in the state courts where the headquarters are situated. So that concludes our discussion of cases for today. Our final topic is an update on efforts in the past year to pass laws relating to trade secret theft or restrictive covenants. While there may have been other efforts around the country in 2014, I think perhaps the most notable legislative efforts occurred in the U.S. Congress, where bills were introduced seeking to create a private right of action for trade secret theft under federal law, and in Massachusetts, where numerous initiatives were proposed in the state legislature. On the federal side, in April 2014, Democratic Senator Chris Coons and Republican Senator Orrin Hatch introduced the so-called Defend Trade Secrets Act. This bill proposed amendments to the Economic Espionage Act, which in its current form allows only federal prosecutors to bring criminal trade secrets charges against persons who have stolen trade secrets. The new bill proposed to amend the Economic Espionage Act to add a remedy on the civil side, allowing private citizens or companies to sue trade secret thieves under federal law. Currently, companies pursuing trade secret misappropriation claims are pretty much limited to state law remedies, and as a result often find themselves limited to litigating those claims in state courts. A similar bill to the Senate's bill was introduced in the House of Representatives, also by a bipartisan group of congressmen, in July of 2014. This is called the Trade Secrets Protection Act. Both of these bills echoed and expanded upon legislative efforts in 2013, the year previously, to create a federal private right of action for trade secret theft. While neither of the 2014 federal trade secret bills made it out of committees in the Senate or House, signs do point to the possibility that momentum is on the side of a federal private right of action for trade secret theft being enacted in the future. First, both 2014 bills and also the 2013 efforts were introduced with bipartisan support. Second, these efforts have enjoyed broad support from industry and trade groups, including the National Association of Manufacturers and the Information Technology Industry Council. Also, there have been a number of high-profile trade secret thefts and prosecutions in the news in the past couple of years. And I think there's a perception that the U.S. economy is vulnerable to cyber espionage and trade secret thefts from abroad. So to the extent those items keep popping up in the news, I think there'll still be an impetus behind these bills. Finally, there's also a push from some legal quarters to standardize laws on trade secrets. Right now, companies can only bring trade secret misappropriation claims under the patchwork of state law, most of which is based on some form of the Uniform Trade Secrets Act, but which still has big differences from state to state. You may wonder, is anyone putting the brakes on these efforts in Congress? And the answer is yes. In September 2014, a group of law professors in the intellectual property and trade secrets fields published a letter opposing the efforts to create the federal trade secrets law. In addition to noting that the bills, if passed, could result in a dramatic uptick of trade secrets lawsuits filed in federal courts, they made several other arguments, including that existing state law is sufficiently uniform and effective. The new law would be parallel and redundant with respect to those existing state laws, and also that the new law could bring a host of unintended consequences, such as misuse of lawsuits for anti-competitive purposes, risk of accidental disclosure of trade secrets through court filings and otherwise, and damages to collaboration among businesses and to individual workers looking to change jobs. I certainly feel sure that we haven't seen the last of these legislative efforts at the federal level, and we'll see whether and how they are continued in the coming year. Turning to the state level, for my money, Massachusetts was the most interesting state for legislative efforts in the trade secrets non-compete area in 2014. Indeed, I would call it a hotbed of such efforts. So far, however, there have been no results in terms of new laws being enacted. But I'll just review, the laws that were proposed. Like most states, Massachusetts currently does not have a state statute governing general enforceability of non-compete agreements. When asked to enforce a non-compete or non-solicit agreement, courts there engage in an analysis based on the reasonableness of the restriction in the context of the relevant facts. In 2014, however, Governor Deval Patrick proposed a fairly radical bill in the Massachusetts legislature seeking to make non-compete agreements unenforceable with some exceptions. This would have made Massachusetts hostile to restrictive covenants in a manner similar to that prevailing in California. The idea behind the bill was to encourage the continued development of Massachusetts high-tech sector, including by encouraging spin-off companies to better compete with high-tech companies in other states, including, of course, California. Despite robust debate and the governor's backing, the bill was not enacted. There were some interesting compromise bills also proposed in Massachusetts, including a bill to ban the use of non-competes for non-exempt workers, a bill to require advance notice and consideration for non-competes proposed after the start of employment, and a bill like Florida's statute that would create presumptions regarding the reasonableness of duration and scope of non-compete agreements. But again, none of these passed. But it's easy to predict that there will be more such bills proposed in 2015 in Massachusetts and maybe other states, and the time may soon be ripe to get one enacted there. Finally, there was another legislative effort of note in Massachusetts in 2014. Massachusetts is currently one of 2 states which have not enacted some form of the Uniform Trade Secrets Act, or UTSA. In the past year, efforts were made to adopt the UTSA in Massachusetts, but those efforts, like the proposed non-compete bills, did not succeed. The fight to adopt the UTSA in Massachusetts is not over. A new UTSA bill has already been proposed for consideration in the upcoming 2015 session in the Massachusetts legislature. So there's a lot to look forward to in 2015. All of these issues that we've touched on today will no doubt continue to be litigated or debated in legislatures somewhere in the U.S. We hope our review of 2014's highlights has been helpful to you, and we thank you for tuning in. And Kirsten, can I hand it off to you?
Absolutely. Thank you. We would like to thank our speakers and to all of you on the line for joining us today. At this time, we will conclude the webinar, but for those of you who have submitted questions, the speakers will endeavor to address them via email in the coming few business days. And for everybody else, all of our registrants, again, we appreciate your attendance. And in approximately 2 to 3 business days, Epstein Becker Green will communicate the availability of the webinar recording and access to the PowerPoint materials. Thank you very much.